Could you pay $500, $5,000, $50,000, or even $500,000 of your own money for an unauthorized commitment? Even if you could, would you want to? It could happen to any government employee. If you answered no to any of these questions, then this training is for you. An unauthorized commitment is many times referred to as a UA. Let's start with what a UA is. It is an act by an employee who obligates the government to pay for goods or services without the proper authority. It is an agreement that is not binding on the government solely because the government representative who made it lacked the authority to enter into that agreement. What does this mean? It means that unless you have been delegated the authority in the form of a contracting officer's warrant or designation letter, you cannot legally obligate the government for goods or services. If you order or accept goods or services from a vendor without a valid contract, that is a UA. And since you are the one who ordered or accepted the items, you are the committer and could ultimately be liable for the cost of what you ordered or accepted. In order for a UA to be paid by the government, it has to be ratified. A ratification is the act of approving a UA by an official who has the authority to do so. Approving officials for ratification include the chief of the contracting office, or the principal assistant responsible for contracting, or the head of the contracting activity, depending on the dollar amount of the UA. To avoid committing UAs, we need to understand how they occur. It is important to realize that unauthorized commitments do not always result from intentional acts. They can occur as a result of a simple misunderstanding between government personnel and a vendor. Changes in procedures. The expiration of a valid contract. Errors made in the ordering of goods or services that are not covered by a contract. Violations of credit card limits. And errors made during emergencies. Now, let's cover some of these errors in a little more detail. A case that resulted from a misunderstanding happened when a sales representative delivered a newly developed chemical analyzer to a hospital laboratory. He told the lab staff that the analyzer was free. The staff thought it was a great deal and signed an agreement to keep the analyzer. What they did not know was that the free lease was tied to a minimum annual reagent order. A year later, the lab received a bill for $30,000 because they failed to order the minimum reagent quantities required in the agreement. This is an unauthorized commitment. Why? Because even though the staff was not aware of the actual cost to lease the analyzer, their actions caused a UA for $30,000. The staff was not authorized to obligate the government, and therefore the government is not legally obligated to pay the bill. In another example, John's office had a laundry service contract with a local vendor. John's contract had option years, and he did all the required paperwork to request that the option be exercised. Although John did not receive a copy of the option modification authorizing another year of service, he assumed it was done because the vendor's employees still picked up and delivered the laundry. When John received an invoice from the vendor stating that DFAS had rejected it, he called DFAS and was told there was no contract on record that covered the time period of the invoice and therefore it could not be paid. John soon discovered that the modification to exercise the option was never completed. John's case is an unauthorized commitment as well. Why is John at fault? Even though John assumed that contracting had exercised the option, he did not follow up to obtain a copy of the modification before allowing the vendor to perform the work. Did contracting receive the option request? Was there a miscommunication? In any case, always ensure you have documentation that a contract is in effect. Never assume. If you do not receive a copy before the option or performance start date, contact your local contracting office before the vendor begins or continues work. Sometimes mistakes are made by ordering goods or services from a valid contract that is not specifically designed for the items you need to order. Contracts contain the specific items a contractor is to provide, an agreed-upon price, and during an agreed-upon time period. This is called the scope of the contract. Going outside the scope of the contract causes unauthorized commitments. For example, take the case of Karen, who noticed that the floor in the conference room was dirty. Knowing that the commander was briefing later in the room, she asked Bob from their contracted housekeeping service to clean it. Bob said, "Sure, no problem." A month later, the contractor billed an extra $500 for the cleaning service. This, too, is an unauthorized commitment. Why? If Karen had read the contract, she would have known that it did not include cleaning the conference room. Again, each contract has specific work to be performed during a specific time period. Asking a contractor to do something not specifically identified in a contract will likely result in a UA. Always read the contract in detail, and, if you're unsure what work is allowed, then ask your local contracting office. UAs can also result during emergencies. In the Army Medical Command, we deal in life and death situations every day, situations that require quick decisions and contribute to a high number of UAs. In our final scenario, let's address an emergency case. A patient requiring immediate care for an aneurysm was admitted. The patient required an urgent surgical procedure to place an endovascular medical device of an unusual type not carried in the normal inventory. The doctor placed an emergency call to a local vendor who delivered the item, and the patient's life was saved. However, no contract was in place, and the doctor was not authorized to place the order. This is also an unauthorized commitment. But the doctor saved the patient's life. How can that be wrong? With emergencies, it is important to know that there is a contracting officer on call 24/7, 365 days a year in every MedCom regional and subordinate command, and the staff duty has the phone numbers. A contracting officer can resolve these cases by authorizing the order through legal means. Using proper procedures, even in emergency situations, ensures the integrity of the acquisition process prescribed by law, ensures the government receives a fair price, and ultimately saves the doctor time from doing paperwork needed for a UA. The paperwork required to process a UA is lengthy and involves time and review at many levels in the chain of command. First, the committer of the UA must fill out a MedCom Form 747R and include an official, detailed statement indicating the who, what, where, when, and why of the event. Next, the committer's supervisor must also state the events leading up to the UA. This paperwork is then reviewed, and a statement is required by the individual's unit commander, director, or activity chief with the rank of 06 or equivalent. The reviewer must outline remedial actions taken to prevent a reoccurrence and describe disciplinary action taken against the committer. The document is also reviewed and signed by the individual's commander, who can concur or recommend further actions. Next, a contracting officer must investigate and review the file to determine if the facts in the statements are accurate, consult with legal counsel, determine if the price was fair and reasonable, and verify if funds were available at the time of the occurrence. Based on the answers found during this investigation, the contracting officer will then decide whether or not to recommend ratification. Then, the action receives a formal legal review to ensure it is legally sufficient, and finally receives a recommendation from the chief of the contracting office before it goes to the approving authority. A UA cannot be paid until it is ratified by the approving authority, and there isn't any law, regulation, or policy that says a UA has to be ratified. The MedCom tracks UAs, which are briefed through command channels by name, probably not something you want to be known for. Disciplinary actions can range from a simple counseling to termination of employment, and it can also include criminal charges with fines up to $5,000, imprisonment for up to 2 years, or both. Spending the government's money without authorization is serious business. Remember, too, that even when disciplinary action is taken, it does not in any way alleviate the committer from the financial liability that can follow if the UA is not ratified. Until the action is ratified, the committer is responsible for the debt to the vendor. Speaking of vendors, our responsibilities to them include paying our bills on time and maintaining a professional relationship. Many UAs can take several months and in some cases years to report, investigate, and ratify, resulting in payment delays and many times creating hardships on our vendors who must hold our debt for items they have already paid for and delivered. If an action is not ratified, the vendor may seek payment through the court system by suing the committer personally, resulting in additional personal time from work and court costs. Can you afford to take that chance? Remember that only a warranted contracting officer can obligate the government. This means that only a contracting officer may enter into negotiations, agree to terms and conditions, accept pricing, authorize payments, or make changes to an existing contract. And only a contracting officer is authorized to sign vendor or licensing agreements on behalf of the government, which includes hotel agreements for conference rooms. So, consider this. You wouldn't practice medicine without a license. You wouldn't fly a helicopter without training. And you must not obligate the government without proper written authority. In the end, whether your unauthorized commitment is ratified or not, lasting damage can occur to your career, as well as to the reputation of the command and its business relationships. The best approach is to never depend on later authorization. Do things right the first time. Someone once said it is easier to ask for forgiveness than permission. However, when it comes to a UA, forgiveness is not guaranteed and can be very expensive. Always abide by the law and follow proper acquisition procedures. Do things right the first time, so you do not need to ask for forgiveness or possibly take out a bank loan. Remember, advice is just a phone call away. If you have further questions or concerns regarding this training or any other contracting matter, call your local contracting office or legal counsel. Working together, we can eliminate unauthorized commitments and save MedCom resources to allow the MedCom to do what it does best: save lives.